Imagine sitting in a windowless room, the heavy steel door clicking shut behind you. You are entirely isolated from the outside world, facing trained investigators whose sole objective is to extract information. The psychological weight of this environment is immense, designed specifically to break down resistance and secure a confession. This is the reality of police questioning, a high-stakes encounter where the balance of power heavily favors the state. To navigate this inherently coercive environment, the American legal system relies on a specific set of procedural safeguards. These protections ensure that an individual's constitutional liberties are not crushed under the weight of state authority. Understanding these safeguards is not just about memorizing a script from television. It is about recognizing the fundamental boundaries between citizen and government. Please note that the following information is provided for educational purposes only and does not constitute formal legal counsel. The origins of these modern safeguards trace back to a dusty interrogation room in Phoenix, Arizona in 1963. A 23-year-old man named Ernesto Miranda was arrested and subjected to 2 hours of intense questioning by detectives. He eventually signed a written confession to serious crimes, a document that would become the central piece of evidence leading to his conviction. However, a critical flaw existed in the process that secured that confession. At no point during the 2-hour ordeal was Miranda informed that he had a choice in the matter. He was never told he could refuse to answer questions, nor was he advised that he could request the presence of a lawyer to guide him through the perilous legal landscape. This glaring omission propelled the case all the way to the United States Supreme Court. In the landmark 1966 decision of Miranda v. Arizona, the court delivered a ruling that fundamentally reshaped American jurisprudence. Chief Justice Earl Warren, writing for the majority, recognized that the psychological manipulation inherent in modern police interrogation could easily overcome a suspect's will, rendering any resulting confession involuntary. The court's decision was anchored deeply in the Fifth Amendment of the United States Constitution. This amendment contains the self-incrimination clause, which explicitly states that no person shall be compelled in any criminal case to be a witness against himself. It is a profound declaration that the state must prove its case using its own resources, rather than forcing the accused to supply the rope for their own hanging. Yet, a constitutional guarantee written on parchment offers little comfort to a suspect sweating in a holding cell if they do not know it exists. The Supreme Court realized that for the Fifth Amendment to have any practical meaning, suspects needed to be explicitly informed of their protections before questioning began. The right to remain silent had to be actively communicated, not just passively assumed. Equally crucial to the court's calculus was the Sixth Amendment, which guarantees the right to counsel. Navigating the treacherous waters of a criminal investigation requires specialized knowledge that the average citizen simply does not possess. A lawyer serves as a vital buffer between the immense power of the state and the vulnerability of the isolated suspect. By fusing the protections of the Fifth and Sixth Amendments, the Supreme Court created the now famous Miranda warning. This mandated litany acts as a procedural shield, ensuring that any waiver of constitutional rights is made voluntarily, knowingly, and intelligently. It leveled the playing field, transforming abstract constitutional theory into a tangible, everyday safeguard. However, a common misconception is that police must recite these rights the moment they place someone in handcuffs. In reality, the legal requirement to issue the warning is triggered by a very specific combination of circumstances known as custodial interrogation. Both elements of this legal trigger, custody and interrogation, must be present simultaneously for the rule to apply. Custody, in a legal sense, does not always mean being locked in a jail cell. It occurs when a reasonable person in the suspect's position would feel that their freedom of action has been curtailed to a degree associated with a formal arrest. If an officer stops you on the street for a brief chat and you are free to walk away, you are not in custody and no warning is required. The second element, interrogation, extends beyond explicitly asking questions. It encompasses any words or actions on the part of the police that they should know are reasonably likely to elicit an incriminating response from the suspect. This means investigators cannot use psychological ploys or stage conversations designed to provoke a confession without first reading the required warnings. If law enforcement officers fail to provide the warning before initiating a custodial interrogation, the consequences for the prosecution can be severe. Under a legal doctrine known as the exclusionary rule, Any statements or confessions obtained in violation of these procedures are generally deemed inadmissible in court. The state is barred from using the suspect's own unmirandized words to prove their guilt at trial. The exclusionary rule serves as a powerful deterrent against police misconduct, ensuring that constitutional violations yield no evidentiary reward. It forces investigators to adhere strictly to procedural guidelines. This principle of suppressing tainted evidence is what gives the 1966 ruling its formidable teeth. Interestingly, the suppression of a confession does not automatically mean a suspect walks free, a reality demonstrated by Ernesto Miranda's own subsequent trial. After the Supreme Court threw out his original confession, the state of Arizona prosecuted him a second time. They simply relied on different evidence, including witness testimony, and secured a conviction without using the tainted statements. Understanding how to properly utilize these protections is just as important as knowing they exist. If a suspect decides they do not want to speak, they must do so with unambiguous clarity. Simply staying quiet while detectives pepper you with questions is not enough to formally invoke your protections. This counterintuitive reality was codified in the 2010 Supreme Court case, Berghuis v. Tompkins. The court ruled that a suspect must explicitly state that they wish to remain silent or that they do not want to talk to the police. To activate the right to silence, one must actually speak up and claim it. The process for securing a lawyer follows a similarly strict standard. A suspect must make a clear and unequivocal request for legal representation. Vague statements like wondering aloud if an attorney is needed are often deemed legally insufficient. A suspect must state definitively that they want a lawyer. The moment a suspect clearly invokes their right to counsel, all questioning must immediately cease. Investigators cannot badger the suspect, nor can they return a few hours later to try again, unless the suspect initiates the conversation or a lawyer is finally present. This creates an impenetrable wall of protection around the individual. As with most legal doctrines, there are narrow exceptions to these stringent rules. The most notable is the public safety exception, established in the case of New York v. Quarles. If police are dealing with an immediate, overarching threat to the community, they can ask targeted questions before reading any rights. Imagine a scenario where officers pursue an armed suspect into a crowded supermarket and apprehend him wearing an empty shoulder holster. The immediate need to locate the discarded weapon to prevent a bystander from getting hurt overrides the standard procedural requirements. Questions about the gun's location in this exact moment are permissible, and the answers can be used in court. Another crucial nuance involves spontaneous utterances. If a suspect is in custody and suddenly blurts out a confession without any prompting or questioning from the police, that statement is entirely admissible. The protections apply to government compulsion, not to a suspect's voluntary decision to volunteer information unprompted. The balance between effective law enforcement and individual liberty is a constant tightrope walk. These procedural safeguards are not designed to help criminals escape justice, but rather to ensure that the justice system operates with integrity. A system that relies on coercion to secure convictions ultimately undermines its own legitimacy. Over the decades, the warnings established in 1966 have faced numerous legal challenges. Critics argued they handcuffed police and let guilty parties go free. Yet the foundational ruling survived, largely due to the legal doctrine of stare decisis. Stare decisis is a Latin term meaning to stand by things decided. It is the principle that courts should adhere to historical precedent when making rulings on similar cases. This doctrine provides stability and predictability to the law, ensuring that constitutional interpretations do not swing wildly with every change in the court's composition. The power of stare decisis was vividly illustrated in the year 2000 in the case of Dickerson v. United States. The Supreme Court ultimately voted to uphold the warnings, concluding that the practice had become so deeply embedded in routine police practice that it had become part of the national culture. The concept of mens rea, or guilty mind, is another foundational element of criminal law, representing the intention or knowledge of wrongdoing. While procedural safeguards dictate how evidence is gathered, they ultimately serve to ensure that the state accurately proves this guilty mind without resorting to forced admissions. It forces the prosecution to build a robust, evidence-based case. The legacy of that dusty interrogation room in Phoenix continues to echo through every precinct in the country. Explaining these rights reveals the intricate machinery of the justice system, highlighting the constant friction between state power and individual freedom. It is a reminder that the Constitution is not a self-executing document. It requires vigilance, enforcement, and an informed public to maintain its strength. Ultimately, understanding your rights is the first and most crucial line of defense in any legal encounter. Alongside other fundamental doctrines like habeas corpus, which protects against unlawful and indefinite imprisonment, the protections against self-incrimination and the guarantee of legal counsel are pillars of a free society. They ensure that when the heavy steel door clicks shut, the individual is never truly standing alone against the power of the state.